Good day everyone, my name is Arjan De Juan. Today I will going to discuss to you the Section 1 and 2 of the revised rules in criminal procedure. Section 1 states that time to prepare for trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial shall commence within 30 days from receipt of the pre-trial order. Rule 119 of Revised Rules in Criminal Procedure pertains to the trial phase in criminal cases. Section 1 of Rule 119 outlines the timeline for the preparation and commencement of the trial after a plea of not guilty has been entered by the accused. According to Section 1, once the accused has entered a plea of not guilty, they are entitled to a minimum of 15 days to prepare for the trial. This period allows the accused and their legal counsel to gather evidence, prepare their defense, and make necessary arrangements for the trial proceedings. Furthermore, the rule mandates that the trial must commence within 30 days from the receipt of the pre-trial order. The provision aims to ensure that the trial proceedings are conducted in a timely manner, promoting the swift resolution of criminal cases and upholding the right to a speedy trial for the accused. By setting specific time frames for trial preparation and commencement, Rule 119 seeks to balance the interest of the accused in adequately preparing their defense with the need for expeditious and efficient resolution of criminal cases within the Philippine legal system. Section 2. Section 2 states that continuous trial until terminated postponements. Trial once commenced shall continue from day to day as far as practicable until terminated. It may be postponed for a reasonable period of time for good cause. Section 2 addresses the continuity of trial proceedings once they have commenced and the circumstances under which postponements may be granted. The rule stipulates that once a trial has begun, it should be proceed continuously from day to day as far as practicable until it is concluded. These provisions aims to ensure the efficiency and timely resolution of criminal cases by promoting a consistent and uninterrupted progression of trial proceedings. However, the rule also acknowledges that there may be valid reasons for postponing a trial for a reasonable period of time. Such postponements can be granted for good cause, which typically refers to compelling reasons that justify the delay in the trial proceedings. Examples of valid reasons for postponement may include the unavailability of the key witnesses, the sudden illness of a party or a legal counsel, or unforeseen circumstances that hinder the fair conduct of the trial. By allowing for reasonable postponements for good cause, Section 2 of Rule 119 strikes a balance between the need for continuous trial proceedings and the recognition of legitimate reasons that may necessitate a temporary delay. This provision aims to ensure that trials are conducted fairly and efficiently and in a manner that upholds the principles of justice and due process in the Philippine legal system. The court, after consultation with the prosecutor and defense counsel, set the case for continuous trial on a weekly or short-term trial calendar at the earliest possible time so as to ensure speedy trial. In no case shall the entire trial period exceed 180 days from the first day of trial except as otherwise authorized by the Supreme Court. The Rule 1119 ensures that court cases are scheduled for continuous trial on a regular basis, such as weekly or short-term trial calendars in order to expedite the legal process. The court works with both the prosecutor and the defense counsel to set a trial date as soon as possible. And the trial period should not exceed 180 days from the start of the trial unless authorized by the Supreme Court. This rule aims to promote a speedy and efficient resolution of legal matters. The time limitations provided under this section and the preceding section shall not apply where special laws or circulars of the Supreme Court provided for a shorter period of trial. The Rule 1119 sets a maximum trial period of 180 days from the start of the trial, unless authorized by the Supreme Court. This rule is in place to ensure that legal matters are resolved efficiently and in timely manner. However, there may be exceptions to these time limitations if special laws or circulars from the Supreme Court dictate for a shorter period of trial. That's all. Thank you.
Good morning, ma'am. Good morning, classmate. Today, I will discuss my assigned topic, which is Rule 119, Section 1 and Section 2. Section 1, time to prepare for trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial shall commence within 30 days from the receipt of the pre-trial order. So, this means that before the trial start, they are given a time to prepare for it. After the accused pleads not guilty, they are entitled to a minimum of 15 days to prepare for the trial. This time is crucial for the defense to gather evidence, review the prosecution case, consult with legal counsel, and prepare any necessary witness or documents. Once the plea of not guilty is entered and the accused has had their allotted time to prepare, the trial must begin within 30 days from the receipt of the pre-trial order. This ensures that the legal process moves forwards in a timely manner and that the accused's right to a speedy trial is upheld. These provisions aim to balance the rights of the accused to adequate preparation with need for timely resolution of criminal cases by providing a specific time frame for preparation and commencement of trial. It helps ensure that justice is served efficiently and fairly for all parties involved. Next is Section 2. Continuous trial until terminated postponements. Trial once commence shall continue from day to day as far as practicable until terminated. It may be postponed for a reasonable period of time for good cause. This court shall, after consultations with the prosecutor and defense counsel, set the case for continuous trial on a weekly or other short-term trial calendar at the earliest possible time so as to ensure speedy trial. In number case, shall the entire trial period exceed 180 days from the first day of trial except as otherwise authorized by the Supreme Court. The time limitation provided under this section and the preceding section shall not apply where the special law or circulations of the Supreme Court provide for a shorter period of trial. So this section states that once a trial has begun, it should proceed continuously from day to day as much as possible until it reaches its conclusion. This continuous process helps to speed up the legal proceeding and ensure that the case moves forward without unnecessary delays. While the goal is continuous trial, the court may grant postponements for a reasonable period if there is a valid reason or good cause. This provision allows for flexibility in scheduling to accommodate unforeseen circumstances or legitimate concerns raised by either party. It also states that the court, in consultation with the prosecutor and defense counsel, is responsible for scheduling the cases for continuous trial on a weekly or other short-term trial calendar as soon as feasible. This proactive approach aims to ensure a speedy trial and efficient use of court resources. The entire trial period from the first day of trial should not exceed 180 days unless otherwise authorized by the Supreme Court. This limitation helps prevent prolonged trials and promotes the timely resolution of cases. In addition, the time limitation provides under the section and the preceding section shall not apply where special law or circulars of the Supreme Court provide for a shorter period trial. In overall, this provision emphasizes the importance of speedy trial proceeding while allowing or necessary flexibility and exceptions under certain circumstances of legal framework.
Good day, attorney. I am Ronald Aguirre, and I will discuss this topic about the Rule 119, Section 1 and 2. Now, we will start discussing on Section 1, Rule 119. In Section 1, this mainly focuses on when trial shall commence. So the trial commence in 30 days from the receipt of pre-trial order. In Section 1, the hearing days in the calendar call shall be held from Monday to Thursday, and the court shall call cases at exactly 8:30 in the morning and 2 p.m. in the afternoon. Hearings and motion, arraignment, and pre-trial promulgation of decision shall be held in the morning of Friday. Now we proceed on Section 2. In Section 2, this mainly focuses on the time frame for the conduct of trial in criminal cases or time limit for the trial or criminal cases. In this section, we will talk about the continuous trial system and limitation of the trial period. So in this section, as a general rule, once commenced, the trial shall be continued from day to day as far as practicable until terminated, but it may be postponed for a reasonable period of time for good cause. To ensure speedy trial, the court shall set the case for continuous trial on weekly or other short-term trial calendar at the earliest possible time. So the court shall do so after consultation with a prosecutor and defense counsel. So we'll go ahead to and try to understand deeper what do we mean by continuous trial system. So continuous trial system is trial once commenced shall continue from day to day as far as practicable until terminated, but it may be postponed for a reasonable period of time for good cause. And the next one is the limitation of the trial period. So it means that it shall in no case exceed 180 days from the first day of the trial except as the otherwise provided by the Supreme Court. So that is all part of my report, and thank you, ma'am.
Good day everyone, my name is Ian Bermejo and this is my report, Section 1 and 2. Section 1, Time to prepare for trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare the trial. The trial shall commence with 30 days from receipt of the pre-trial order, Section 6, 38 to 98. Section 2, Continuous trial until terminated. Section 3. Trial or commence shall continue from day to day as far as practicable until terminated. It may be postponed for a responsible period of time for good cause. The court shall, after conciliation with the prosecutor and defense counsel, set the case for continuous trial on a week order short-term trial calendar at the earliest possible time. So, at the end speed trial. In no case shall the inter-trial period exceed 180 days from the first day of trial, except as otherwise authorized by the Supreme Court, Section 8. The time limitation provided under section and the preceding section shall not apply for especially law of circular of Supreme Court provide for a shorter period of trial.
Good morning, attorney. I am John Stephen Fadri, and I'm going to discuss the Section 3 of Rule 119, which is the exclusions. Exclusions. The following periods of delay shall be excluded in computing the time within which trial must commence. Any period of delay resulting from other proceedings concerning the accused, including but not limited to the following. First is the delay resulting from an examination of the physical and mental condition of the accused. If the court orders a psychiatric evaluation of the accused to determine their mental fitness to stand trial, the time taken for this evaluation would be excluded from the trial commencement period. Second, the delay resulting from proceedings with respect to other criminal charges against the accused. If the accused is facing multiple criminal charges in different cases, any time spent in court dealing with those other charges would be excluded from the calculation of trial commencement time for his particular case. Third is the delay resulting from extraordinary remedies against interlocutory orders. If either the prosecution or the defense files an appeal against a preliminary court ruling, the time taken for the appeal process would not count towards the trial commencement time. Fourth is the delay resulting from pre-trial proceedings, provided that the delay does not exceed 30 days. For instance, if there are hearings scheduled for pre-trial motions such as motions to suppress evidence or motions to dismiss charges, any time spent in such proceedings up to maximum of 30 days would be excluded. Delay resulting from orders of inhibition or proceedings relating to change of venue of cases or transfer from other courts. If there's request to change the trial's location or transfer the case to another court, the time spent on proceedings related to this request would not be counted towards trial commencement time. Delay resulting from a finding of the existence of a prejudicial question. If there's a legal issue that needs to be resolved before the trial can proceed, such as determining the validity of the evidence or resolving a legal conflict, the time taken to address this issue would be excluded. And last, delay reasonably attributable to any period, not to exceed 30 days, during which any proceeding concerning the accused is actually under advisement. If there's a period where the court needs time to consider arguments or review evidence before making a decision, up to maximum of 30 days, this time would be excluded from the calculation of trial commencement time. B. Any period of delay resulting from the absence or unavailability of an essential witness. Take note that being absent and being unavailable are different. Let's say there's a criminal trial and a key witness, Mr. A, is crucial for the prosecution's case. However, Mr. A whereabouts are currently unknown, despite diligent efforts by the prosecution to locate him. In this case, Mr. A would be considered absent, as per the paragraph mentioned. Now let's imagine that the prosecution manages to locate Mr. A, but he refuses to appear in court or cannot be compelled to do So even after diligent efforts by the prosecution, in this scenario, Mr. A would be considered unavailable for trial, even though his whereabouts are known. C. Any period of delay resulting from the mental incompetence or physical inability of the accused to stand trial. For example, the trial was delayed for several months due to the mental incompetence of the accused, who required psychiatric evaluation and treatment before being deemed fit to stand trial. D. If the formation is dismissed upon motion of the prosecution and thereafter a charge is filed against the accused for the same offenses, any period of delay from the date the charge was dismissed to the date of the time limitation would commence to run as to the subsequent charge had there been no previous charge. For example, after the prosecution dismissed the initial charge due to lack of evidence, they later filed the same charge against the accused. The period of delay from the date the charge was dismissed to the date the time limitation would commence to run for the subsequent charge is not counted towards the time limit. E. A reasonable period of delay when the accused is joined for trial with co-accused over whom the court has not acquired jurisdiction, or as to whom the time for trial has not run and no motion for separate trial has been granted. For example, in a complex case involving multiple defendants, one of the accused fled the jurisdiction, delaying the trial for the remaining defendants who were joined for trial. Since the court had not acquired jurisdiction over the absent defendant, the delay caused by their absence was considered reasonable and not counted towards the time limit for the trial of the other defendants. F. Any period of delay resulting from a continuance granted by any court, motu proprio, or on motion of either the accused or his counsel, or the prosecution, if the court granted the continuance on the basis of its findings for, in order that the ends of justice served by taking such action outweigh the best interest of the public and the accused in a speedy trial. For example, in a high-profile case, the court granted a continuance after the defense counsel argued that additional time was needed to gather crucial evidence for accused defense. The court, after considering the complexity of the case and the need for a fair trial, ruled that ends of justice served by the continuance outweighed the interest of the public and the accused in a speedy trial.
Good day, ma'am. I'm Earl Fajiculay and I will discuss the Section 3 of Rule 119. As an overview of Section 3 of Rule 119 explains how we count time for trials, it lists reasons when we don't count some delays, making sure trials start fairly and on time. This focuses on the exclusion, which are important because they protect defendant, keep things fair, and follow rules. Exclusion: any period of delay resulting from other proceeding concerning the accused, including but not limited to the following: delay from examination of accused, physical and mental condition. This exclusion covers delays caused by examinations to assist the physical and mental health of the accused. It ensures that the accused receives proper medical and psychological evaluations without finalizing them for the time taken for this assessment. Number 2, delay from proceedings on other criminal charges. This refers to delays resulting from legal proceedings related to other criminal charges against the accused. It acknowledges that the accused may be involving in multiple legal matters and allows for reasonable delay caused by this proceeding. Number 3, delay from extraordinary remedies against interlocutory orders. This inclusion accounts for delays resulting from the pursuit of extraordinary remedies such as appeals or motions against interlocutory orders. Preliminary rulings issued during the trial. It recognized the need for additional time to address legal challenges that may arise during the trial process. Number 4. Number 4. Delay from pre-trial proceedings. This covers delays resulting from various pre-trial proceedings such as hearings, motions, or conferences necessary for the accused and the prosecution have adequate time to address procedural matters before the trial commences. Number 5. Delay from orders or inhibition or change of venue. This refers to delays caused by court orders or inhibition or change of venue, moving the trial to a different location. It allows for the necessary time to address changes in judicial personnel or trial location, ensuring a fair and impartial trial process. Number 6. Delay from finding prejudicial questions. This inclusion applies to delays resulting from the determination of prejudicial questions, which is legal issues that must be resolved from proceeding with the trial. It acknowledges the resolve such questions may take time and should not count towards the trial time limit. And last, number 7, delay during proceedings under advisement. This covers delays from occurring while the court is considering and deliberating on legal matters of rulings related to the accused. It allows for reasonable time for the court to review and decide on issues without penalizing the parties involved. Exclusion V. Any delay resulting from the absence or unavailability or of unessential witnesses. As essential witnesses, it is considered absent when whereabouts are unknown or cannot be determined by due diligence, and available when whereabouts are known but presence for trial cannot be obtained by due diligence. Exclusion C. Any delay resulting from the mental incompetence or physical inability of the accused to stand trial. This covers delays resulting from the mental or physical inability of the accused to stand trial, emphasizing the importance of accommodating the accused condition on the legal process. Exclusion D. An information is dismissed upon motion of prosecution. Any delay from dismissal date to subsequent charge date is excluded. This exclusion addresses delays from resulting the dismissal of information upon motion of the prosecution and subsequent refiling of charges. The period of delay excluded is specified. Exclusion E. A reasonable period of delay when the accused is joined for trial with a co-accused over whom that court has not acquired jurisdiction, or as to whom the time for the trial has not run and no motion for separate trial has been granted. Exclusion F. Any period of delay resulting from a continuance granted by any court or on motion of either the accused or his counsel or the prosecution of the court granted. The continuance of the basis of its findings set forth in the order that the ends of justice are by taking such actions outweigh the best interest of the public and the accused is speedy trial. This exclusion covers delays resulting from a continuance granted by the court. The criteria for granting a continuance and the factors considered the balancing the interests involved are discussed. That's all, and thank you.
Good day, ma'am. My name is Camille Fadera from Block 2. I will discuss and explain the Section 3 of Rule 119, which is the following periods of delay shall be excluded in computing the time within which trial must commence. Letter A. Any period of delay resulting from other proceedings concerning the accused, including but not limited to the following. Number 1. Delay resulting from examination of physical and mental condition of the accused, which is delay resulting from an examination of physical and mental condition of accused refers to additional time taken in legal proceedings when the court orders an assessment of evaluation of the accused's physical or mental health. This examination aims to determine the accused's competency to stand trial, their mental state at the time of the offense, or any relevant condition that affect the legal process. Number 2. Delay resulting from proceeding with respect to other criminal charges against the accused. Delay resulting from proceedings with respect to other criminal charges against the accused refers to the additional time taken in the legal process when there are multiple criminal charges pending against the same individual. These charges can either be separate cases or different counts within the same case. These proceedings typically involve investigating, prosecuting, and adjudicating the charges separately, which can lead to delays in the overall legal process. Number 3. Delay resulting from extraordinary remedies against interlocutory orders. Delay resulting from extraordinary interlocutory orders refers to the additional time taken in legal process due to the filing and resolution of special appeals or applications against interlocutory orders. These extraordinary remedies are typically filed when a party believes that an interlocutory order, which is an order issued during the course of litigation before the final judgment, has significant legal errors or would cause irreparable harm if addressed immediately. Number 4. Legal resulting from pre-trial proceedings provided that the delay does not exceed 30 days. When delays result from pre-trial proceedings, it means that certain legal process and preparations need to be completed before the trial can officially begin. These pre-trial proceedings are crucial for ensuring that the trial is conducted fairly and effectively or efficiently. When explaining delay resulting from pre-trial proceedings to others, you can mention that this delay are necessary to allow both parties to adequately prepare their cases, exchange information, and address any preliminary legal issues. It is important to emphasize that these delays keep within reasonable time frame, not exceeding 30 days as you mentioned, are a standard part of legal process and are intended to facilitate more effective and judge trial. By allowing time, pre-trial proceedings, parties have the opportunity to gather evidence, engage in negotiations, and address any legal matters that may arise before the trial begins. This ultimately helps to ensure that the trial proceedings is smoothly and that all parties have fair opportunity to present their cases. Number 5. delay resulting from orders of inhibition or proceedings relating to change of venue of cases or transfer from other courts. Delay resulting from orders of inhibition or proceedings related to a charge of venue of cases or transfer from another courts typically occur when there is need to address jurisdictional issues or logistical considerations that could affect the proper handling of the case. When this delays to others, you can mention that orders of inhibition, change of venue, or transfer from other courts may be necessarily to ensure that the case is heard in the appropriate jurisdiction or venue. These processes are essentials for upholding legal principles and ensuring that the case is handled in a fair and impartial manner. While delay resulting from these orders or proceedings can be frustrating, it is important to emphasize that they are essential of the legal system and ensuring that justice is served. Properly addressing jurisdictional issues and logistical considerations help to safeguard the rights of all parties involved and uphold the rule of law. Number 6. Delay resulting from finding of existence of a prejudicial question. When a prejudicial question arises in legal proceedings, it can cause delays as the court may need to address this issue before proceeding further with the case. Prejudicial question is a matter that must be resolved before the main case can continue, as its outcome can have a significant impact on the main case. The delay resulting from finding of a prejudicial question to others, you can say that the court has identified a critical issue that needs to be resolved before the case can move forward. This process is necessary to ensure that the main case is decided fairly and justly. While these delays can be frustrating, addressing prejudicial questions is important for upholding the principles of justice and ensuring that all relevant issues are properly considered in the legal proceeding. Number 7. Delay reasonably attributable to any period not to exceed 30 days during which any proceeding concerning the accused is actually under advisement. Delay reasonably attributable to any period not to exceed 30 days during which any proceeding concerning under the advisement means that if a decision or ruling related to the accused is being deliberated or considered by a court or in a relevant authority, any delay that occurs during this period is allowed and not counted towards the overall time limit for the trial. In other words, if there is a proceedings or legal matter that directly impact the accused and the decision for that matter is being carefully considered by the appropriate entity responsible for making the decision. Any delay that occurs during this period is considered reasonable and does not exceed a maximum of 30 days. This grace period is provided to ensure that the decision-making process is thorough and fair. During this time, the trial may be temporarily halted or postponed until the proceeding under advisement is concluded. Once the decision is made, the trial can proceed accordingly. The purpose of this provision is to ensure that important legal matters related to the accused are given due consideration without negatively impacting the overall efficiency of the trial process. Letter B. Any period of delay resulting from the absence or unavailability of an essential witness. For purpose of this subparagraph, an essential witness shall be considered absent when his whereabouts are unknown or his whereabouts cannot be determined by due diligence. He shall be considered unavailable whenever his whereabouts are known but his presence for trial cannot be obtained by due diligence. Letter C. Any period of delay resulting from the mental incompetence or physical inability of the accused to stand trial. If the accused found to be mentally incompetent or physically unable to stand the trial, any delay that occurs is not counted towards the time limitation for the trial. And if the accused is deemed mentally unfit or physically incapable of participating in the trial proceedings, any time that passes while the accused is in this condition does not count towards the trial must take place. This is done to ensure that the accused is given a fair opportunity to participate in their own defense and that their rights are protected. The trial will be postponed until the accused is deemed fit or unable or able to stand trial, at which point the time limitation will start running again. Letter D. If the information is dismissed upon motion of the prosecution and thereafter a charge is filed against the accused for the same offense, any period of delay from the date the charge was dismissed to the date the time limitation would commence to run as the subsequent charge had there been no previous charge. If the prosecution files a motion and the court dismisses the information or charges against the accused but later decides to file new charges for the same offense, any delay that occurs between the dismissal of the previous charges and the date when the limitation would normally start for the subsequent charges is not counted towards the time limitation. In the simple way, if the charges are dropped and then new charges are filed for the same offense, any time period between the dismissal and the start of the new charges does not count towards the time limit within the prosecution must bring the case to trial. It's as if the clock starts again for the new charges. This is done to ensure that the accused is not disadvantaged by the dismissal of the previous charges and allow the prosecution to proceed with a fresh case. Letter E. Reasonable period of delay when the accused is joined for trial with a co-accused over whom court has not acquired jurisdiction or as to whom the time for trial has not run and no motion for separate trial has been granted. In my understanding, a reasonable period of delay can occur when the accused is being tried together with another person who the court does not have jurisdiction over, or whose time for trial has not yet expired and no request has been made to have separate trial. This means that the court may need to delay the trial for reasonable amount of the time until it can properly handle the case of the other persons involved. This delay is considered reasonable because it is necessary to ensure a fair proceedings and to avoid any potential prejudice that may arise from separating trials. And the last is any period of delay resulting from an continuance granted by any court motu proprio or on motion of either the accused or his counsel or the prosecution. If the court granted the continuance on the basis of its findings set forth in the order that the ends of justice served by taking such action outweigh the best interest of the public and the accused is in a speedy trial. This period of delay can occur or in a court case when the court itself, the accused or their lawyer or the prosecution request a continuance. A continuance means that the proceedings or trials are temporarily postponed. This delay may be granted by the court if it believes that it is necessary for the proper administration of justice, and if this decision is based on the court's findings that the benefits of the delay outweigh the interests of both public and the accused in having a speedy trial. That's all, and thank you.